Welcome back to the deep dive. Our listener today has shared a truly an exceptional stack of sources,
It really is a compelling collection.
compiled by constitutional and corporate lawyer Mr. Zaheer Ahmad Meer, and it's all focused on one powerful, really persistent idea.
That justice and legal accountability, well, they should be universal, not conditional.
Right.
It's a huge thesis, spanning over 1,000 years of legal history. We're sort of tackling the question of whether ethical obligations and the rule of law stop at a national border.
Or if they are, in fact, something more fundamental.
Exactly. Are they fundamental truths that apply to all humans, all governments, regardless of geography or political power?
So our mission for this deep dive is to, I guess, extract and connect two pretty profound parallels that seem to underpin this whole universal demand for justice.
And the sources lay them out so clearly.
They really do. First, we're looking at how global legal authority was even established in the first place. We're going to be contrasting the 7th century mission of Mu'adh ibn Jabal
An incredible story.
with the modern International Court of Justice, the ICJ,
And then there's the other side of the coin, the complementary idea,
which is
the demand for absolute personal accountability from people in power, from state officials, will draw a sort of a continuous thread from the anti-corruption model set up by Caliph Umar.
which is just staggering when you get into the details.
It is right through to the groundbreaking and frankly necessary legal reckoning of the Nuremberg trials after World War II.
What's so immediately clear from these sources is that this whole struggle, the legal and the moral struggle, it's a continuum. It doesn't matter if we're talking about a 7th century governor or a 21st century head of state. The foundational principles are, well, they're eerily consistent.
And they're all designed to protect the vulnerable. That's the key. And they always challenge this idea that sovereignty is some kind of shield for tyranny.
Absolutely. So we promised to unpack the legal architecture, the political challenges faced by people who tried to set these systems up centuries ago.
And how those same challenges are still echoing today inside institutions like the UN and the ICJ.
Okay, let's unpack this, starting with the birth of truly global jurisprudence.
And the intellectual leap that was required to make it all work. So we start with this one singular historical moment that the sources say really codified the structure for legal scalability.
And this is the dispatch of Mu'adh ibn Jabal.
Yes. As a judge and governor to Yemen sent by the Prophet Muhammad. And you have to understand, this wasn't just some administrative appointment.
It was more than that.
Oh, much more. It was a conscious, deliberate move to export this new developing legal system far beyond the immediate political and, cultural center of Medina.
And that action alone, just sending him, it fundamentally stress tests the whole legal framework.
Completely. I mean, think about it. Medina was the source. It's where revelation was happening, where direct guidance was available. Yemen, on the other hand,
It was huge, distant.
and diverse. It had its own complex tribal customs, its own unwritten laws. So to establish justice there, you needed a system that was robust enough to be universal.
But flexible.
Exactly. Flexible enough to handle completely new situations, local novelty.
And the sources say the genius of this system is all captured in one conversation.
It is this famous dialogue that happened right before Mu'adh left. And it's this conversation that establishes the whole methodology, a hierarchy of jurisprudence.
It really does mirror how modern courts work, how they prioritize sources of law.
From a written constitution down to reasoned precedent, it's all there in this one exchange.
So let's detail that conversation, because it really does outline the steps a judge has to take when they're facing a new case in a new land. The prophecy starts it off.
He asks Mu'adh a simple question. How will you judge?
And Mu'adh's answer, his first answer, is what anchors the whole system.
It is. He says, by the book of Allah, this is your primary source, the unassailable, non-negotiable legal bedrock.
It's like a modern constitution.
Or a foundational treaty. It's the fixed boundary of justice. It establishes stability.
But then the prophet Yeki pushes him. He introduces the real-world challenge of legal application.
He asks, if you do not find it.
Which is such an important question. It's an acknowledgement that no foundational text can ever detail every single circumstance that's going to come up.
Especially not in a place like Yemen or any rapidly expanding territory. The world is just too complex.
So Mu'adh then gives the second source.
He says, by the sunnah of his messenger, the practical application, the living example. the precedent set by the central authority.
So in today's legal terms, that's our case law.
It's precedent, established tradition that interprets the foundational text. You see the hierarchy forming.
It's a crucial distinction, isn't it?
Mm-hmm.
The first source is fixed text. The second is living practice.
Mm-hmm.
But even with those two combined, you're still going to have gaps, especially in a new legal frontier like Yemen.
Which leads to the pivotal, really the revolutionary final question from the Prophet Yemen.
If you do not find it there.
And this is where Mulad's response defines the entire intellectual character of the legal system. He says, I will judge by my reasoning.
Ijtihad.
Ijtihad. Personal intellectual effort. Reasoned judgment. And with the Prophet's approval of that answer, you have the institutional sanctioning of human intellect as a legitimate, necessary source of law.
But only when the primary sources are silent.
That's the key. It's the final step in the hierarchy.
I think we need to just pause here for a second, because this isn't just about, making a good guess.
No, not at all.
This is a specific legal methodology.
Mm-hmm.
What does sanctioning ijtihad really do for a transnational legal system? What does it enable?
It enables scalability and resilience. I mean, the biggest challenge for any universal law, any system that claims to be universal, is how you apply it consistently across totally different geographies and cultures.
Without it just breaking apart into 1,000 different local systems.
Exactly. You risk it fracturing into contradictory rulings. Ijtihad provides the necessary legal tools to prevent that.
Tools like what, specifically?
Well, tools like qiyas, which is analogical deduction. You take a new case and you match it to an established ruling based on a shared underlying cause or reason.
So you're reasoning by analogy to extend the law.
Precisely. And then there's istisla, which is judging based on public interest or public good. It allows a judge to rule in a way that upholds the spirit of the law and benefits the community, even if there isn't a direct text covering the issue.
That's the technical nuance that makes this so powerful. If justice is truly universal, it has to have the tools to address, say, a trade dispute in a Yemeni court that maybe never happened in the markets of Medina.
And this dialogue essentially provides that judicial framework. It's a method for managing legal novelty while preserving unity and core principles.
So the source material argues that this single moment, this conversation, it's what establishes global Islamic jurisprudence.
It does. By making justice portable, principled, and intellectually adaptive, it meant the legal system was neither geographically stuck nor, bound by a super narrow literal reading of the text.
A codified international judicial ethics.
And crucially, established cross-border legal authority that was anchored in universal moral principles. This was a clear, functioning model of transnational jurisdiction.
Centuries before the concept was sort of reinvented in the modern West.
Many centuries.
Okay, so if Muad's mission proved that justice could transcend the political center, then the modern International Court of Justice, the ICJ, is the institutional realization of justice transcending state sovereignty itself.
That is the perfect transition, because the ICJ deals exclusively with disputes between states. It operates under the UN Charter, various international conventions.
And it's when we look at how it's applied to the crime of genocide, that's where we see the 21st century version of that same universal demand to protect the vulnerable no matter where they are.
Absolutely. Let's look at the first key case in our sources, Bosnia and Herzegovina v. Serbia and Montenegro. This was in 2007.
And this ruling didn't just, say genocide is bad. It did something much more fundamental.
It redefined a state's active duties, its obligations. The case, of course, stemmed from the horrific atrocities during the Srebrenica massacre in 1995.
Horrific.
And for the very first time, the ICJ held a state, in this case, Serbia, legally responsible for the specific act of failing to prevent genocide.
Okay, so you mentioned earlier how tricky the issue of state sovereignty is. This gets right to the heart of it. How did the court establish that Serbia had an actual, actionable duty to prevent something carried out by groups that weren't technically part of its own state structure?
That's the million-dollar question. And the court's analysis was incredibly nuanced. They didn't just make a moral judgment, they anchored it in law. Specifically, the 1948 Genocide Convention.
Which obligates states to prevent and punish genocide.
Right. But what does prevent really mean? The court determined that this duty to prevent is one of, and this is the legal term, due diligence.
Due diligence, meaning what?
It required Serbia to use all means reasonably available to them to influence the actions of the perpetrators, the Bosnian Serb forces. And the court found, based on the evidence, that Serbia had immense political, financial, and military influence over those forces.
But they didn't use it.
They deliberately chose not to utilize that capacity. So the failure wasn't just inaction, it was a breach of a positive legal duty.
That shift is massive.
Yeah.
From just prohibiting an act to demanding active prevention, it creates a positive obligation that follows state power wherever it reaches.
Yes. It implies that if a state has the resources and the influence to stop a universal crime, it must act, even if the crime is happening technically in a neighboring territory.
It pierces the veil of sovereignty.
It does. The court affirmed that the Genocide Convention established obligations erga omnes,
Which means
obligations owed by a state to the entire international community as a whole, not just to one other state that it has harmed directly. It's a direct challenge to the old absolute view of sovereignty that says what happens within my borders or my sphere of influence is my business.
this is, no, some crimes are everyone's business.
Exactly. Your borders do not excuse inaction when universal crimes are imminent.
Okay. So if the Bosnia case established the principle, this responsibility to prevent, then the case of the Gambia v. Myanmar,
Concerning the Rohingya,
that case proved the accessibility of this system. It showed that your size or your geopolitical power doesn't matter when you're seeking justice.
this case, filed in 2019, is such a powerful contemporary example. You have the Gambia, a small nation in West Africa, a few million people,
Taking on Myanmar, a large Southeast Asian country.
over atrocities committed against the Rohingya Muslim minority. And the core legal question, right at the start, was one of standing.
Right. How could the Gambia even bring a case when it wasn't directly harmed by what was happening thousands of miles away?
In most international disputes, you have to show direct harm to your state or your citizens. But here, the Gambia overcame that hurdle by invoking that same principle, the erga omnes nature of the Genocide Convention, which the court had reinforced in the Bosnia case.
So because the prohibition of genocide is a universal obligation.
Any state that signed the convention has a legitimate legal interest in making sure every other state complies with it.
So the Gambia could act as a sort of proxy for the entire international community.
It steps forward for universal justice. It's a mechanism that allows a smaller, less powerful nation to hold a larger one to account on behalf of all humanity.
The optics of that are just as stunning as the legal precedent. And the ICJ acted quickly.
They did. They issued immediate provisional measures against Myanmar in 2020. The court ordered Myanmar to take all measures within its power to prevent all genocidal acts against the Rohingya,
And, crucially,
to ensure that its own military and police forces do not commit genocide. And on top of that, they were ordered to preserve all evidence related to the allegations.
it's a legal protective umbrella.
It is. It cut right through Myanmar's argument that this was all just an internal affair and nobody else had jurisdiction.
This continuum is really remarkable when you lay it out like this. You have Musa'ad using sanctioned reasoning, Ijtihad, to make sure the spirit of the law could be applied universally as the state expanded.
And you have the ICJ using the Genocide Convention to apply that same universal principle of protection, overcoming the modern legal barrier of national sovereignty.
So the shared ratio decidendi, the core legal reason, is what?
It's simple, but it's revolutionary. Justice is borderless. It's this constant institutional demand that oppression is not excused by geography, and that the law must be designed, whether through reasoned adaptation like Ijtihad or an international treaty, to seek out and protect the vulnerable, wherever they might be.
That's the external mechanism of justice, holding states accountable from the outside. But that's only possible if the people inside those states, the ones actually wielding the power, are themselves subject to rigorous, unflinching review.
Which brings us to the internal dimension of accountability.
And this shift takes us from the geographical reach of law to the ethical demands that are placed on the individuals who are actually entrusted with power.
Yes, we transition to the tenure of the second Caliph, Umar ibn al-Khattab. His governance model was intensely focused on preventing internal abuse.
The sources call this the world's first anti-corruption governance model.
And it was radical for its time, genuinely radical, because its starting assumption was that power corrupts.
So it required constant vigilance.
An institutionalized suspicion, even of the most trusted and successful officials.
And this wasn't about catching, minor bureaucrats skimming a little off the top. This was aimed right at the top.
At the most powerful men in a rapidly growing empire. The system had to be designed not just to appoint good people, but to catch and instantly correct bad behavior when it inevitably appeared.
The scope of it is what's so incredible. Umar's empire was huge. It stretched from Egypt to Persia.
And the governors he appointed held immense authority. political, military, and financial. These were men who could have easily carved out their own little kingdoms.
So detail the logistics of this. Who exactly was getting summoned back to Medina to face this audit?
He regularly called back the key figures, the ones governing the vast, resource-rich provinces. This included Amr ibn al-As, the conqueror and governor of Egypt.
A province that was basically the breadbasket of the region. Hugely important.
Absolutely critical for grain and wealth.
Yeah.
He also summoned Muawiyah ibn Abi Sufyan, the governor of Syria, which was a major military and strategic frontier.
And not just the old territories.
No, he was just as tough on the governors of the new major cities like Kufa and Basra in what is now Iraq, even the governor of Bahrain. These were the power centers.
The sheer logistics of that in the 7th century are staggering to think about.
It's incredible.
Summoning the governor of Egypt meant weeks of travel just to present yourself for a review. That alone tells you that for Umar, accountability was completely non-negotiable.
It was prioritized above almost everything else, above political convenience, above military expediency. The time and political capital it took to regularly haul these powerful men back to Medina for questioning was enormous.
And the process itself? It was rigorous. It targeted the 3 areas where power is most often misused.
Public service, personal finance, and popular complaint.
Okay, let's break those down. First, their conduct.
He examined their conduct toward the general population. He was apparently deeply concerned that his appointed officials were acting like masters, not servants. He wanted to know how they treated the people.
And second, their finances. This is what feels so modern.
This is truly revolutionary. It was an early form of mandatory asset declaration and lifestyle audit. Before a governor took up his post, his assets were recorded.
And when he was summoned back,
He had to account for his wealth again. He was actively looking for unexplained wealth. Any sudden, dramatic accumulation of assets that couldn't be justified by their official salary.
So this sounds exactly like the unexplained wealth orders and anti-corruption measures that governments struggle to implement effectively even today.
It is the historical blueprint for it. If an official, say the governor of Bahrain, suddenly acquired huge tracts of land or was living in conspicuous luxury, he would be challenged publicly to explain the source of that wealth.
And if he couldn't,
If the explanation was inadequate, if the wealth was disproportionate to his legitimate earnings, Umar would confiscate the excess.
all of it.
Often he would divide it. Half would be returned to the state treasury, the Beit al-Mal, and the other half would be left with the official. The message was undeniable. Public office is for public service, not personal enrichment.
And that third mechanism, addressing public complaints, that was the check on power from below.
Yes. He created an institutional channel for any citizen, even the poorest, to lodge a complaint directly against the highest-ranking officials. The entire accountability process was fueled by popular oversight.
It ensured that power was responsive, transparent.
He would often hold these examinations of the governors publicly, sometimes in the mosque after prayers, allowing everyone to witness the scrutiny. There was nowhere to hide.
And this whole rigorous system was built on a profoundly ethical philosophy, one that just completely inverted the normal relationship between a ruler and the people.
It's captured in this core quote from Umar, which became the mandate for governance. You have been appointed over the people, not raised above them.
That distinction, over versus above, that's entire deep dive on leadership theory in just 6 words.
It is. It just strips away any aristocratic notion of inherent privilege. It replaces it with the demanding responsibility of being a trustee.
So authority isn't a source of honor and wealth. It's a temporary, precarious burden of responsibility.
You're just a manager of the state's affairs and the people's welfare. And because that was his core mandate, the consequences for breaking that trust were immediate and irreversible.
The sources are clear on this. The consequence was absolute. Any governor who misused power was dismissed immediately.
No exception.
But we're talking about men who controlled entire regions, who often had armies loyal to them. How was Umar able to make this consequence so absolute without it all just falling apart into civil war or political collapse?
I think it's because he demonstrated that the ethical health of the state itself was more important than the political convenience of keeping one powerful but compromised man in place.
He was willing to risk short-term instability for long-term integrity.
Yes. And that immediate public consequence served as a massive deterrent for every other official. They knew the audit was coming, and they knew dismissal would be instant and public. It set this historical standard that power must be exercised with humility and transparency.
And that philosophy, that the highest office demands the most rigorous scrutiny. It brings us directly to the modern external reckoning, where the world applied this exact same principle to the architects of global conflict. The transition from Caliph Umar's internal ethical governance model to the post-World War II Nuremberg trials, it's philosophically seamless.
It really is. Both systems are built on the rejection of the idea that centralized power gives you immunity. The only real difference is the scale of the crime and the scope of the judges.
After the unbelievable atrocities of the Holocaust and World War II, the international community had this unprecedented challenge.
How do you hold an entire state apparatus, the Third Reich, accountable for crimes that were, in many cases, actually sanctioned by their own national laws?
And the solution was the International Military Tribunal, the IMT, at Nuremberg in 1945.
This was revolutionary because the victors, the Allies, they chose to submit the defeated to a legal process rather than just carrying out summary executions.
They chose to codify justice.
And in doing so, they created the very legal precedents that govern international criminal law to this day.
And just like with Umar's system, the net of accountability was cast very, very widely. It wasn't just about the figurehead.
No, it applied that same principle that the entire system must be held responsible. It's crucial to see who is actually in the dock.
The sources detail this really comprehensive targeting of the whole criminal infrastructure. It wasn't just Hitler, who was already dead, or Himmler.
No. The list included the most prominent Nazi leaders, of course, men like Hermann Goering, Rudolf Hess, Joachim von Ribbentrop. But critically, they also prosecuted the high-ranking army generals.
Like Alfred Jodl and Wilhelm Keitel.
Yes, which ensured that the military chain of command couldn't just claim they were innocent soldiers following orders. They also targeted the industrialists.
The men who made the war and the atrocities financially possible.
The men who ran massive corporations that used slave labor from concentration camps. The inclusion of people like Albert Speer and the exposure of companies involved in the war economy sent a clear signal.
That economic power, corporate complicity, and state crimes, that doesn't get a pass either.
And finally, and this is so important, they targeted the propagandists.
Like Julius Streicher.
The publisher of the virulently anti-Semitic newspaper Der Stürmer. This established that the people who ideologically design, incite, and normalize violence bear criminal responsibility, even if they never physically pulled a trigger.
It's a holistic approach. It recognizes that these massive state crimes are a collaborative project.
It involves political, military, economic, and ideological wings. All are complicit.
But the real legal novelty of Nuremberg was in the charges themselves. Many of them had never really been formally defined or applied in international law before.
That's right. There were three major categories, and they remain the foundation of international criminal law. The first was crimes against peace.
Which was about what?
It targeted those who planned, prepared, initiated, or waged a war of aggression. This was a hugely novel concept. It criminalized the very act of starting the war.
It challenged the traditional idea that a sovereign state just has the right to declare war whenever it wants.
Exactly. The second category was more traditional, but it was applied with a new rigor. War crimes.
These are violations of existing laws of war, right?
Yes. Things established by the Hague and Geneva Conventions. Murder, ill treatment of civilian populations, killing of prisoners of war, wanton destruction of cities. These were recognizable crimes, but now they were being applied to individuals at the highest level on a massive scale.
And then there's the third category, which is arguably the most profound contribution to jurisprudence and the direct spiritual heir to all the universal principles we've been talking about.
Crimes against humanity.
This was the breakthrough charge.
It was. It covered acts like murder, extermination, enslavement, and persecution carried out against any civilian population before or during the war. And here's the crucial part.
What's that?
This charge applied even if the acts were carried out by a government against its own citizens.
And even if they were technically legal under the national laws of that state.
Yes. That's the part that places a definitive limit on national sovereignty, rooting law in a universal morality that stands above the state.
And this brings us to the core takeaway from this whole segment. The declaration from the tribunal that cemented its legacy and just radically redefined the relationship between the individual and the state.
It was an unflinching declaration. Obedience to orders is not a defense for crimes against humanity.
That one phrase is the philosophical engine of modern accountability. Before this, military doctrine, for centuries, had relied on the defense of superior orders.
The Nuremberg defense, as it's now ironically known, The idea that if your commanding officer orders you to do something, your personal responsibility is either erased or at least heavily mitigated.
Nuremberg just shattered that legal shield.
Completely. The Declaration established the primacy of individual conscience and universal law over any military or state hierarchy. It meant every soldier, every bureaucrat, every industrialist was individually responsible for the moral and legal consequences of their actions.
Even if those actions were sanctioned by the highest authority in the land.
It forces individuals inside these powerful systems to exercise critical judgment. It mandates that when a superior's order clearly conflicts with an evident universal crime against humanity, the individual is not just permitted, but is legally obligated to refuse that order.
It totally redefines the idea of state agency. It says the state is not some moral black hole that can just absorb individual guilt.
The act of participating in a universal crime is a personal choice, and the individual must bear the consequences. This is the direct, external, modern parallel to Caliph Umar's internal ethical demand on his governors.
Your rank does not excuse your crime.
It never does.
So let's pull this entire narrative together now. The sources have shown us this persistent theme, this thread running across vast bands of history and culture. What is that shared philosophical truth, the ratio decidendi, that links Umar's dismissal of a corrupt governor to the Nuremberg convictions?
It's the ultimate reversal of the common misconception about high office. The shared principle is this: power does not excuse crime, it increases responsibility.
It's an inversion of how we normally think about power.
Completely. The very presence of authority, whether it was delegated by a caliphate or seized by a totalitarian regime, it heightens the legal and moral burden on the person holding that office.
So let's just synthesize the two major convergences we've explored. For you, the listener, starting with the principle of universal reach.
First, you have the convergence on transnational justice. We saw it with Mu'ad's mission, establishing this system of universal, adaptable justice through ijtihad that could travel to Yemen and protect the population there.
And in the modern era.
We see the ICJ invoking erga omnes obligations, this legal tool that allows a small state like the Gambia to legally challenge a powerful state like Myanmar. It proves that justice must follow the oppressed wherever they are and can override national claims of sovereignty to do so.
And the second convergence is on personal accountability.
Yes. We detailed Umar's aggressive internal anti-corruption model, the asset declarations, the public audits, the immediate dismissal, all based on the philosophy that power is just a temporary trust.
And this is mirrored centuries later, externally.
By the Nuremberg Tribunal's landmark decision to dismantle the defense of superior orders. It asserts that no military uniform, no political title, no corporate letterhead grants immunity from accountability for universal crimes.
So what this all ultimately means for you, the learner, is that these sophisticated concepts of international law, they aren't recent inventions.
Not at all. They are the institutionalization of moral and legal truths that have converged across different civilizations and legal traditions for over a millennium.
They show this continuous, persistent human struggle to limit the destructive potential of unchecked, centralized authority.
And these principles, they fundamentally challenge the idea that morality is just relative or culturally defined. They suggest that the duty to protect the vulnerable and the responsibility of the powerful are historical constants.
It's a remarkable insight that the structures we rely on today, the International Criminal Court, the ICJ, the very concept of human rights law, they all stand on ground that was prepared by historical legal thinkers.
Thinkers who understood that if justice is not universal, then ultimately it's meaningless.
This has been a really profound deep dive. We've moved from the legal methodology of the 7th century through the rigorous ethics of early Islamic governance, right up to the codification of modern international criminal law at Nuremberg.
It's a clear line.
Yeah, we've seen that the birth of reasoned transnational justice on one hand and the demand for absolute accountability from those in power on the other. They're really just expressions of the same universal human impulse for fairness.
And that impulse leads us right back to that most challenging declaration from Nuremberg. Obedience to orders is not a defense. It's the ultimate accountability tool. It places the final legal and moral judgment on the individual's conscience.
Even when they're facing immense coercive pressure from a state or a hierarchy.
Especially then.
Now, that decision at Nuremberg was aimed at military generals, at high-ranking Nazi officials. But if we really follow the spirit of that legal declaration, that individual responsibility transcends hierarchy, it has applications far, far beyond global warfare.
Precisely. That's the crucial next step. If we accept that even direct military orders do not excuse the gravest crimes, this raises a really important question for all of us. All of us operating within modern systems of power, large or small.
Governmental, corporate, financial.
Any system. What is your responsibility as an individual agent within that system when your actions or your instructions contribute to institutional harm, to injustice, to corruption?
Even if you are just following the rules or obeying orders from a supervisor or a manager.
That's the question. It shifts the focus from purely structural failure to individual ethical failure. It demands that everyone within the system maintains a moral compass that is independent of the official chain of command.
The burden of conscience, established by the highest legal authority in the world, becomes the final takeaway from this exceptional historical stack.
An excellent point to conclude on. Thank you for sharing your sources and allowing us to take this deep dive into the universal principles of law and justice that seem to bind our history together.
We'll catch you next time for the next deep dive.